Bismillahirrahmanirrahim. Lecture 4 of International Law. Define the public international law and private international law. Also distinguish the public international law from the private international law. International law, also called the law of nations, from practical point of view, primarily is a system regulating the rights and duties of the states. But nowadays, the definition of international law also includes the regulation of relations between states, between multinational companies, INGOs, and individuals. And with the development, international law also has taken cognizance to punish the individuals committing the crime of genocide, race, destruction, and crimes against peace and humanity. International law definition, and the definition, there are two types of definition of international law. First one is a classical, according to which the international law regulates the relations between states. But modern definition, Professor Stark, international law is composed of customary and conventional rules considered to be binding upon the civilized states while conducting their relations with each other, and includes the functioning of international organizations and institutions, their relations with each other and states, and also relations of individuals with states and international institutions. Then the public international law and private international law. Defining the public international law, Professor Berger, public international law is body of principles and rules according to which relations are conducted between the sovereign states and such entities having the status of international legal personality. Private international law, Pitt Cobbett and M.P. Tandon had defined that they were of the view that international law is a body of rules and principles determining questions as to selection of appropriate law and jurisdiction in civil cases which are presented before a court of one of the state for decision involving foreign elements. Before defining difference between public international law and private international law, the gist is that the public international law regulates the affairs and rights and duties of states, vice versa, INGOs, NGOs. On the other hand, private international law is the law which elaborate the questions relating to jurisdictions of conflict of jurisdictions and questions as to be subject of jurisdictions and subjects of international law. The first one difference according to sources. Sources of public international law are customary practices, treaties, writings of the jurists, general principles of law recognized by the states, and judicial decisions, whereas private international law comes from the legislation of individual states to which the litigants belong. The second one is the subjects. Subjects of the public international law are states, international institutions, organizations, servants of the UNO, and individuals. On the other hand, private international law is applicable to the individuals only. Scope. The scope of public international law is wider. It deals universally and regulates the relations between the states, whereas the private international law has a narrow scope and it operates within the mechanism of municipal law. State law. Public international law is not a part of state law, whereas the private international law is an offshoot of state law or a municipal law. Varying nature, the nature of public international law does not vary and it remains same for all the states, for all the subjects. On the other hand, private international law may vary from the state to state. Application. Both criminal and civil cases come under the operation of public international law, whereas private international law deals only with civil cases dealing with conflict of law. Public international law doesn't deal with the conflicts of law, na? Whereas private international law deals with the conflicts of law and questions of law. Na? Jurisdiction. There is no issue in the public international law regarding determination of question of jurisdiction, whereas the private international law primarily deals with the questions determining the jurisdiction. Consent of states. For public international law, the consent of state is necessary, whereas on the other hand, for a private international law, no such consent is required. Object. Public international law conducts the relations of the states with each other, determines their rights and duties, and also regulate the activities of other subjects. Whereas private international law has to determine applicability of two conflicting laws in a particular case involving foreign elements. Therefore, it is concluded that the public and private international law are the branches of international law. Public international law deals with criminal as well as civil cases to regulate the relation between the states, whereas the private international law deals with the civil cases only and is also known as the law dealing with conflicts of law. Thank you.